Good morning, this is your Kelso Report for Monday, April 8th, and I'm your host, Clark Kelso. The Ninth Circuit today gives us cases dealing with storm water runoff from telephone poles, a state's immunity from damages under the 11th Amendment, and a case involving a late tax filing. Topical case. We begin with storm water runoff. The Clean Water Act is designed to restore and maintain the chemical, physical, and biological integrity of the nation's waters. Toward that end, it prohibits the discharge of any pollutant into navigable waters from any point source. Stormwater runoff presents a special problem under the Clean Water Act because it is, as a practical matter, a significant source of water pollution, and yet it is not inherently either a non-point or point source. Under amendments enacted in 1987, the EPA requires permits for most significant stormwater discharges, including those from a prior permitted source or large municipality, and those that are associated with industrial activity. In Ecological Rights Foundation versus PG&E, the primary question was whether pollutants discharged from telephone poles should be categorized as coming from a point source associated with industrial activity. A split panel of the Ninth Circuit held that discharges of stormwater from utility poles were neither a point source discharge nor associated with industrial activity, and therefore were not subject to permit requirements. We'll see what the Ninth Circuit in bank decides, whether they decide to take that particular issue in bank or leave that one alone. Obviously a big issue when it comes to water pollution. Next we have a case involving the 11th Amendment and the state immunity from damages. As part of our unique system of federalism, the 11th Amendment shields non-consenting states from suits for monetary damages brought by private individuals in federal court. The exceptions to this rule are narrow. First, Congress may abrogate the immunity if its intent to do so is unmistakably clear, to enforce provisions of the 14th Amendment. Second, the 11th Amendment does not bar an action for the return of property that the state has seized and holds in trust pursuant to a special state statutory scheme. Apart from these exceptions, private litigants are limited to seeking prospective relief in federal court against a state. In Northeast Medical Services versus California Department of Health Care Services, the 11th Amendment immunity played out to deprive the plaintiff of its effort to recover what it alleged were illegal overpayments that it made to the state under the Medicare program. The plaintiff creatively argued that it actually was suing as an agent of the federal government to protect and safeguard the federal program. But the Ninth Circuit easily rejected that argument, since the reality was the plaintiff was suing to recover money for itself. The 11th Amendment immunity cannot be so easily circumvented. The plaintiff also tried arguing it was recovering its own property. But the Ninth Circuit also rejected this argument, since the payments to the state were not held in separate trust accounts pursuant to a special state statutory program. Instead, the plaintiff was seeking money from the state's general fund, and that is precisely what the 11th Amendment forbids. Finally, it's tax season. So, what better a case to have than penalties for filing your taxes late? Now, when a lawyer or accountant misses a filing deadline, or gives bad advice about a filing deadline, it is of course the client who suffers most immediately. The client may have an action against his or her agent for malpractice, but it is pretty rare to be relieved of the filing deadline simply because your lawyer or accountant made a mistake. That certainly is the lesson in Knapp versus United States, where the client, acting as the executor of an estate, asked his accountant to apply for an extension of the deadline to file the estate tax return. The accountant told the client that the deadline had been extended 1 year, when in fact it had been extended only 6 months. When the client subsequently filed the tax return several months late, the IRS assessed significant penalties against the estate. The client sought a refund of the penalty, arguing that the bad advice received from his accountant constituted reasonable cause to excuse the penalty. The Ninth Circuit disagreed, of course, holding that the duty to ascertain the correct extended filing deadline was the client's, and by relying on the accountant's advice about this non-substantive matter, the client failed to exercise ordinary business care and prudence. So it looks to me like the client's next move will be against the accountant, trying to hold the accountant accountable for his mistake. That's it for today's Kelso Report. Have a great day in the law.